Welcome to this explainer. Okay, we've all been there, right? Someone looks you right in the eye, they make a super firm promise, and then they just back out. It's incredibly frustrating on a personal level. But what happens when that broken promise literally ruins your livelihood? What if it costs you thousands of dollars or entirely changes the trajectory of your life?
Well, that leads us to today's massive question. Can you actually sue someone over a broken promise if you never signed an official contract? Traditional contract law relies heavily on a bargained for exchange. But what happens when that's just missing? Are you totally out of luck? Before we completely unravel that mystery, a huge welcome to all the law students cramming for exams out there, and of course, all the curious minds joining us today. If you love digging into how the rules of our society actually work, please hit that like button, subscribe to the channel, and absolutely drop your thoughts and opinions in the comment section as we go. It's a massive help to us. All right, let's dive into this. Here is our roadmap for this explainer. We are going to cover the broken promise problem, the 5 legal elements, the Katie Scawthorne case study, promissory estoppel versus consideration, remedies and applications, and we'll wrap it up with some bar exam success tips. Section 1. The broken promise problem. Enforcing promises without consideration.
So normally, the absolute golden rule of contracts is consideration. That means both sides are giving something of value. But strict adherence to that rule can sometimes lead to incredibly unjust results. What's really interesting here is how the law created a specific solution for this exact problem. It's the equitable doctrine of promissory estoppel. Basically, it acts as either a sword or a shield, bridging the gap to prevent a promissor from unfairly yanking back a promise after the damage is already done. Moving on to Section 2, the 5 legal elements, Restatement Second of Contracts, Section 90. Now, to actually wield this sword or shield, we need a solid framework. For the law students, this means committing the Restatement Second of Contracts to memory. Promissory estoppel is an equitable doctrine that binds parties to a promise even when traditional consideration is missing. But it only works if that promise induced foreseeable detrimental reliance, and enforcing it is literally the only way to prevent a major injustice. It effectively stops, which just means prevents, the promissor from arguing that the lack of a formal contract gets them completely off the hook. All right, here are the 5 specific elements you've got to prove. 1. A clear and definite promise. We're not talking vague opinions or predictions here. 2. The promissor must have reasonably expected that you would rely on it. 3. Actual reliance. You really did change your position based on what they said. 4. That reliance must have been reasonable and justifiable given the circumstances. And 5. The crucial gateway. Injustice can only be avoided by enforcing the promise. And listen closely to this part. That reliance must be detrimental. You must have changed your position for the worse. If the promise actually ended up benefiting you somehow, the court is absolutely not going to step in. Section 3. Case study, Katie Scawthorne, Ricketts v. Scawthorne, 1898. Okay, picture this. We are traveling all the way back to 1898 for a truly foundational case. There's a young woman named Katie working in a store. Her grandfather wants to provide for her, so he hands her a note for the massive sum, especially back then, of $2,000. He tells her, "I have fixed out something that you have not got to work anymore." Relying entirely on this promise, Katie immediately quits her job. Her grandfather pays 1 year's interest, but sadly dies before paying the principal. And guess what? His executor refuses to pay the rest. So here is the massive legal tension. The executor is arguing, hey, look, this was just a nice, gratuitous gift. Katie didn't give her grandfather anything in return. There was no bargain for exchange, therefore no consideration, and therefore no contract. The question is, can a court legally force the estate to pay out a mere gift? Well, what did the Nebraska Supreme Court hold? They said yes. So the crucial point here is that the court fully admitted the note lacked traditional consideration. However, the grandfather intentionally made that promise, knowing full well it would lead Katie to give up her livelihood. She foreseeably relied on it to her detriment by literally quitting her job. The court declared it would be grossly inequitable to let the executor dodge payment just because there wasn't formal consideration. The grandfather's estate was stopped from denying the promise. Section 4. Promissory estoppel versus consideration, a common pitfall. Now that we've seen a clear victory, I really need to raise a massive red flag. Do not confuse these two concepts. Promissory estoppel is not just some special type of consideration. It's a completely alternative theory. Think of it as your substitute, your absolute backup plan, when traditional bargain for consideration just isn't there. When you are analyzing a broken promise, always look for a traditional contract first. Only if consideration is completely lacking or highly doubtful should you pivot to your promissory estoppel argument. Section 5. Remedies and applications as justice requires. So, what do you actually get if you prove all 5 elements? Well, Section 90 famously states that the remedy granted may be limited as justice requires, and that means judges have enormous flexibility here. Unlike standard contract breaches where you'd usually get expectation damages, meaning you get the full value of the promised bargain, courts in these cases frequently award reliance damages. Basically, they just want to put you back in the exact position you were in right before the promise was made. That means compensating you for out-of-pocket expenses or lost wages, kind of like covering Katie's lost income from the store. It's all about tailoring the fix to cure that specific injustice. And you know, this flexible tool gets used everywhere. It rescues family promises, sure, but it is heavily relied upon in charitable subscriptions. Say a hospital starts a huge building project based on a donor's pledge. It's also huge in pre-contractual negotiations, like when a developer spends thousands on surveys just relying on a landowner's assurance before the final deal is inked. It's even used against employers making promises about pensions or brokers who promise to secure you insurance and then entirely forget to do it. Section 6. Bar Exam Success Tips. How to Analyze the Issue. Okay, let's bring the whole shebang home. Law students, if you are going to be tested on this, here is exactly how you structure your analysis for maximum points. Step 1, explicitly check for consideration first on your exam paper. Then you pivot. State the Restatement 90 rule crystal clearly. Next, methodically walk through all 5 elements. And this brilliantly illustrates the key to a top grade. Do not just list the facts. You've got to explain exactly how the facts satisfy each element. Detail how that reliance was foreseeable and, crucially, detrimental. Finally, argue why enforcement prevents injustice, and explicitly point out that the judge has the flexibility to limit the remedy to reliance damages as justice requires. All right, let's test that out right now with a final provocative thought from our practice problems. Imagine a local hospital announces a brand new pediatric wing. A super wealthy philanthropist pledges $5 million in writing. Relying on that exact pledge, the hospital goes out, hires architects, and signs major construction contracts. But a year later, before paying a single dime, the philanthropist dies. The estate then refuses to honor the pledge, arguing it was merely a gift without consideration. So, should the hospital win under promissory estoppel? What do you think justice requires in this scenario? Do they get the full $5 million in expectation damages, or just the reliance damages to cover those specific architect fees? Debate your legal rulings in the comments section below. Thank you so much for joining me for this explainer. Keep learning, stay curious, and please don't forget to like and subscribe on your way out. Catch you next time.